Almost every Ohio family I sit down with asks me the same question before we finish the first conversation. Do I need a will or do I need a trust? The honest answer is that most Ohio professionals need both, but that answer only means something once you understand what each one actually does. And the reason this question has confused so many people for so long is that almost every answer you can find online is either too simple to be useful or it is designed to sell you something. This video is different. By the time it ends, you will know exactly what a will does, what a living trust does, how they compare across 9 specific factors, and which combination makes sense for the life you have actually built in Ohio. I'm Andrew C. Goodwin, the principal attorney at Rhodium Law. I help Ohio business owners, professionals, and their families craft estate plans that protect what they've worked so hard to build. Estate planning is not the lane that I thought I would occupy. I spent 15 plus years in IT before I ever set foot in a law school classroom. After that, I spent time in a large law firm and then as in-house counsel at a global health system, drafting and negotiating complex commercial agreements. But during the early days of the pandemic, I recognized that my mother needed care, dementia and kidney disease. She needed someone close by 24/7. I stepped away from the career path I was on and became her primary caregiver for 5.5 years. My father had gone through his own dementia journey before that, so I'd already watched what it looks like when a family has to navigate a medical crisis without a plan in place. That experience built this practice. I've been on both sides of this conversation. I've watched the trust-only plan, the will-only plan, and the no plan at all scenario play out in real Ohio families. I'm going to give you the version of this conversation I wish every Ohio family had before they needed it. Before I walk you through the comparison, I want to give you one somewhat simplified sentence that clears up most of the confusion. Because if you understand this one idea, everything else in this video will make sense immediately. A will is a set of instructions that take effect after you die. A trust is a legal entity that owns your stuff and operates during your lifetime and beyond. That's it. That single distinction is the source of every difference between the two instruments. Here is why it matters structurally. When your night comes, Ohio law steps in to manage the distribution of any assets that were left only in your name. And here's the part that's not always well understood. Probate is the legal process Ohio uses to transfer any asset titled solely in the name of someone who has died. Joint ownership bypasses probate. So do beneficiary designations on retirement accounts and life insurance, as well as just transfer on death elections. So do payable on death registrations on bank accounts. So does trust ownership. But anything left in your individual name alone has to go through probate. Your will tells the court what to do with those solely titled assets. The court steps in, the process begins. A funded living trust generally avoids probate entirely because at the moment you pass away, your assets are not in your individual name. They are in the trust name. There is nothing left in your sole personal name for the court to handle. The trust simply keeps operating with a new person at the helm according to the instructions you left inside it. Everything else we are going to cover today flows from that single idea. Let me take each instrument separately. First, what a last will and testament actually does in Ohio. A will is a legal document where you tell Ohio 3 things. 1. Who receives your property after you pass? These are your beneficiaries. 2. Who is in charge of making that happen? That person is called your executor. 3. If you have minor children, who will serve as their guardian? When you pass away, your will is filed with the probate court in the Ohio county where you last lived. The court reviews it, confirms it is valid, appoints your executor, and supervises the transfer of your property. That process is Ohio's default system for sorting out a deceased person's estate. A will is the most straightforward estate planning instrument to draft. It's well understood. Every probate court handles wills routinely. For certain situations, which I will define in a few minutes, a well-drafted will may genuinely be the right answer. But the limitation that drives most of the conversation at my firm is this. A will guarantees probate. That's not a flaw in the document. That is how a will works. By definition, a will is a set of instructions to a probate court. If a will is your only instrument, your family will be in Ohio probate court. That court process generally runs 6 to 12 months and carries costs that commonly land in the range of 3 to 7% of the estate's total value. I covered that process in detail in the prior video in this series. The link is in the description. So the threshold question becomes, is probate a desired outcome for your family? For most of the Ohio professionals I work with, the answer is no. Now, let's look at a revocable living trust. A revocable living trust is a legal entity you create while you are alive. You give it a name. You name a trustee. To start, that is almost always you. You transfer your assets into the trust's name. You become what the law calls the grantor, the trustee, and the beneficiary all at once. In practical terms, you still control everything, but technically, the trust owns it, not you personally. That structural difference produces 4 distinct benefits. 1. It can bypass probate entirely. Because the trust owns your assets, there is nothing in your personal name for a probate court to process at your death. Your successor trustee steps in and the trust keeps running. Transfers typically take weeks, not months. No court filings, no 3 to 7% fee. 2. It protects your privacy. Ohio probate is a public record. Anyone can walk into the courthouse or search online and access a probate file. They can see what you owned, who inherited it, and what your accounts were worth. A trust keeps those details private. Barring any contests, nothing is filed publicly when the trust settles. 3. It plans for incapacity, not only for death. This is the benefit most people overlook. A will does nothing for you if you become incapacitated. It only activates after you die. A revocable trust has built-in successor trustee provisions that activate if you become unable to manage your own affairs. If you face dementia, stroke, or a serious illness, the person you name steps in and manages the trust immediately. No court-appointed guardian needed, no frozen accounts, no emergency filings. 4. It handles complicated situations cleanly. Blended families, a special needs child, a family business, real estate in multiple states. A trust can carry a long list of conditions and instructions that a will cannot hold. There is one cost that wills do not have, and it is the one that matters most for this conversation. A trust requires funding. Drafting the trust document creates the legal entity. Funding the trust is the second step. Retitling your home into the trust name, retitling your bank and investment accounts, updating beneficiary designations to route correctly. A trust that sits in a drawer and was never funded is a legal document attached to nothing. It holds no assets. It accomplishes nothing. This is the most common trust failure I encounter. A family comes to me after a loved one has died. They say, we had a trust. Why is everything in probate? The answer, in almost every case, is the same. The trust was drafted. The trust was never funded. The document was complete. The work was not. Now let me give you the comparison across the 9 factors that matter most. Probate. A will goes through probate. A funded living trust generally avoids it entirely. Privacy. A will is a public court record. Anyone can review it. A trust is private. The terms are generally not filed publicly. Speed. A will-based estate in Ohio typically runs 6 to 12 months plus through probate before your family receives anything. A trust-based estate generally settles in a matter of weeks if only immediate outright distributions are desired by the grantor. Cost at death. A will subjects your estate to Ohio's probate process, which commonly carry costs that land in the range approaching 3 to 7% of the estate's value. A funded trust typically avoids that cost entirely. Cost to set up. A will is less expensive to draft. A trust requires more time and more work, both to draft and to fund, so the upfront investment is higher. Incapacity planning. A will does nothing if you are incapacitated. It activates only at death. A revocable trust has built-in incapacity provisions that activate while you are still alive. Minor children guardianship. This is a critical point. A will handles the guardianship designation for your minor children. A trust does not. This is one of the primary reasons the answer for most Ohio professionals is both instruments, not just a trust. Even if you create a trust, you need a pour-over will alongside it for the guardianship provision alone, not to mention the safety it provides for any assets that were not funded into the trust during the grantor's lifetime. Blended families and complex distributions. A will can address these situations, but with less precision. A trust handles them cleanly with staged distributions, conditions, and long-term sub-trust provisions for beneficiaries who need them. Out-of-state real estate. If you own property in another state, a vacation home, a rental, inherited land, a will triggers a separate probate in that state. This is called ancillary probate. A trust avoids it entirely. For many of the Ohio professionals I work with, a funded revocable living trust-based plan with a pour-over will is the approach that accomplishes their objectives. This means the answer is not will versus trust. It is a fully funded revocable living trust as the primary instrument, plus a pour-over will as a backstop to catch anything that was not transferred into the trust, plus function to specify the minor guardianship designation. That combination handles probate avoidance, privacy, speed, incapacity planning, and complexity in a single coordinated plan. A will-only plan may be the right answer for some Ohio families, though. Allow me to explain. I want to be direct about this. Not every Ohio family needs a trust. There are situations where a well-drafted will may be the correct and complete answer. Here's the checklist. All 7 of these should be true for a will-only plan to be the right fit. 1. You do not own real estate, or the only real estate you own is held jointly with a spouse. 2. You do not have a blended family. 3. Your total estate is modest enough that Ohio probate costs would not be a significant burden on your heirs. 4. You do not have minor children or a special needs beneficiary who needs structured long-term support. 5. You do not own a business. 6. You have no significant concern about incapacity planning. Your spouse is capable and willing to handle your affairs if something happens to you. 7. You do not own property in more than one state. If every single one of those is true for your household, a well-drafted will may be all you need. I personally don't suggest a trust for someone whose situation does not call for one. But if even one of those is false, and for most of the Ohio professionals I work with, several of them are false, you should be at least considering a trust. I want to address this directly because I know what some of you are thinking right now. Okay, I will just go online and get the trust document. Problem solved. Here's what that actually looks like in practice. The drafting step is the beginning of the work, not the end of it. I've seen trusts that were drafted years earlier, sometimes by an attorney, sometimes through an online service, that have never been funded. The home is still titled only in the decedent's name. The investment accounts were never retitled. The beneficiary designations were never updated. The trust was signed and filed away, and the family assumed the job was done. It was not. An online document service will give you the trust form. It will not instruct you to file a new deed with the county recorder to retitle your home. It will not walk you through what a lender needs to know when you transfer your house into a trust. It will not coordinate your retirement account beneficiary designations so the trust works as intended. It will not flag which assets must be physically retitled and which pass through beneficiary designations instead. You get the document, you do not get the work that makes the document function. And the cost of that gap does not show up when you sign the papers. It shows up when someone has just died, and the trust that was supposed to keep the family out of probate court cannot do that because it never held anything. One source found that approximately 58% of respondents experienced family disputes or had assets fall under court control due to inadequate or non-existent estate planning. Let that sink in. In my experience, planning in advance can prevent many types of problems that occur after a loved one passes away. If a friend stopped me after church on a Sunday and said, "Drew, give it to me straight. Do I need a will or a trust?" Here's what I'd actually say. If your situation is genuinely simple, no real estate, no blended family, no business, no minor children, a modest estate, and a spouse who can handle everything, a well-drafted will may be the right answer. Go get it done. Don't overcomplicate it. if you own a home in Ohio, if you have retirement accounts and life insurance, if you have children you want to protect, if you've been putting this off for a few years because the process felt complicated, then for someone in your situation, the default answer is a funded revocable living trust paired with a pour-over will. That combination handles the probate question, the privacy question, the incapacity question, and the complexity question in one coordinated plan. If you own a business, have a blended family, have a special needs family member, have out-of-state property, or have any financial complexity at all, then you definitely need to be in a real conversation with someone who will look at your specific situation, not make a decision based on a website. Here's the frame I leave most people with. A living trust is not a luxury item. For a working Ohio professional who has spent 20 or 30 years building something, a home, a retirement account, a business, a family, a funded trust is simply the right tool for the situation you have actually created. The wrong answer is, I don't know. The right answer is a decision made with clear information about the life you are actually planning for. I want to close with something I think about often when I'm working on a trust for an Ohio family. Most of the clients I work with built their lives the same way. Steady, disciplined. They paid their mortgage on time. They funded their retirement every year. They showed up for their kids. They ran their business or showed up to work when it would have been easier not to. They built something that took decades and required more patience than most people realize. A funded trust is, in a real sense, a final expression of that same discipline. It's the decision to say, I built this carefully, and I am going to make sure it transfers carefully. I'm not going to leave my family guessing about what I wanted, fighting over what I meant, or waiting 14 months for a court to tell them they can have what I already decided was theirs. That's not a legal task. That is a final act of provision. That is a final act of love. The question is never really will versus trust. The question is whether the life you built deserves a plan that matches the care you put into building it. Always remember, the best estate plan is the one you finish correctly before it's needed. If this was useful, subscribe. I publish a video every week on Ohio estate planning, all focused on what Ohio families actually need to understand before they need it. My goal is to help you make informed decisions before it is too late. There's a free resource in the description below, our Trust versus Will Comparison Guide, which walks through the 9-factor comparison we covered today in a format you can keep and share. Just click the link. One last thing, I am an attorney, but watching this video does not make me your attorney. This video is merely general information and does not constitute legal advice. If your situation needs real attention, please bring it to someone who will look at your specific circumstances. Strategize, secure, shine. I'll see you soon.